Assalamu alaikum. Hope you guys are doing well.
So, our today's topic is the free movement of goods. We will discuss all the articles in detail. The free movement of goods is an essential element of the internal market, and the decisions of Court of Justice support the achievement of this aspect of economic integration. A central policy of the EU has been the establishment of an internal single market in which the free movement of goods, persons, services, and capital is ensured. The European Court of Justice has supported the implementation of the single market and the free movement of goods through its decisions. Article 28 of the TFEU promotes the free circulation of goods within the EU by establishing a customs union. The customs union prohibits the charging of any duties on imports and exports within the member states of the EU, or the levying of any charge having the equivalent effect as a custom duty. So members are not independent to set their own rules and charges while carrying on the trade with non-member states. Instead, all the members will follow the same set of rules. According to the Article 29 of TFEU, products coming from a third country shall be considered to be in free circulation in a member state if the import formalities have been complied with and any custom duties or charges having equivalent effect which are payable have been levied in that member state, and if they have not benefited from a total or partial drawback of such duties or charges. Now moving towards the Article 30, which is related to the trade between the EU member states. It is as follows. Custom duties on imports and exports and the charges having equivalent effect shall be prohibited between the member states. This prohibition shall also apply to the custom duties of a fiscal nature. In the case of Wengen and Luce, it was stated that Article 30 has the direct effect and can be relied on by the individuals before the national courts. In the case of Commission versus Italy statistical levy case, the court defined a charge having equivalent effect as any pecuniary charge, however small and whatever its designation and mode of application, which is imposed unilaterally on the domestic or foreign goods by reason of the fact that they cross a frontier and which is not a customs duty in the strict sense. In this case, the small amount was claimed on the imported goods for gathering statistics on trade patterns. It put the imported goods at a disadvantage as compared to the domestic goods, so it had an effect equivalent to the customs duty. It is the effect of the charges that matters and not their purpose. In the case of Diamanter Bidders versus India Max, the charge on diamonds imported into Belgium to contribute to a social fund for workers in the diamond industry was found to be a charge having equivalent effect. The ECJ held that the prohibition on charges having an equivalent effect to a customs duty also applies to the goods imported directly from the third countries. This means that a common customs tariff duty can be levied on such goods, but no other charges can be added by the member states. In the case of Denkovic versus France, it was argued that a charge on imported meat was equivalent to a tax payable by French slaughterhouses. Sometimes it becomes difficult to create a distinction between taxes and charge having equivalent effect. However, the Court of Justice found that the charge constituted a G due to the fact that it was imposed under a different criteria to the tax imposed on the national suppliers. The EU Treaty does not contain any defenses to the breaches of Article 30 TFEU. However, there are three instances where a charge may be lawful. We will discuss all three of them. First is a payment for a service. For this exception to apply, there must be a specific benefit individually conferred on the importer or exporter. If it is a benefit in the general interest of all the exporters or to the public at large, it will not qualify. Charges are allowed where they only form compensation for services rendered to the importer on a voluntary basis. For example, an importer may voluntarily request to use a warehouse with cooling facilities owned by the state, while awaiting for the further shipment of the goods. If so, the state may charge a reasonable fees for this service. For instance, in the case of Katsky versus Commercio Estero 1975, there was a quality control carried out by a member state on the products for the export alone. and it cannot be regarded as consideration for a specific benefit actually and individually conferred. Similarly, in the case of Commission versus Italy Statistical Levy, 1969, the issue was regarding the sum which was used to pay for the gathering and publication of statistics on the trade patrons. The court held that it is the effect, not the purpose of the levy, that matters, and since extra fees and charges are likely to put imported goods at a disadvantage as compared to the domestically produced goods, so the effect was equivalent to the customs duty. In addition, there is the case of Bresciani 1976, where it was held that charges in connection with the veterinary inspections were not acceptable because they were not in the individual interest of the importers. In the case of Commission versus Belgium 1983, it was held that charge for any service provided to the importer will be lawful if it is based on the actual cost of providing it. Now, moving towards the second exception, which is related to the charge for inspections mandatory under European Union law. This exception applies when a member state charges a fees for an inspection, where the inspection is required for the European Union directive, but the directive does not specify who should pay for it. As in the case of Bohis versus Netherlands 1977, the court held that a fee for the health inspection of bovine animals required by a community agricultural regulation before export to another state did not constitute an illegal charge equivalent to an export duty, provided the fees covered only the actual cost of the inspection. Now moving towards the last exception, which applies to the cases where the same taxes are applicable both on domestic as well as the imported goods, or where the product is not manufactured domestically. As in the case of Cooperativa Cofruta 1987, where the consumption tax was imposed on the bananas imported in Italy. It was held not to be the breach of Article 30 because there was no discrimination based on the origin of the products.
Article 110 prohibits discriminatory taxation, which favors the domestic production of goods over the goods imported from other member states. The aim of this article is to achieve fiscal neutrality between the domestic and imported products. In the case of Ludic 1996, it was clearly mentioned that Article 110 has the direct effect. The tax discrimination can be in any form, even in the ways of collection, as in the case of Commission versus Ireland 1980, where the importers had to pay tax immediately. On the other hand, domestic producers had several weeks to pay the tax. Internal tax was defined in the case of Cooperativa Cofruta as a consumer tax which is imposed on both imported products and domestic products, but in practice applies almost exclusively to imported products because domestic production is extremely small. So it does not constitute a charge having an equivalent effect to a customs duty on imports within the meaning of Articles 9 and 12 of EEC Treaty. If it is a part of a general system of internal dues applied systematically to the categories of products in accordance with the objective criteria, irrespective of the origin of the products, it therefore constitutes internal taxation within the meaning of Article 95. The only difference between Article 110, subsection 1 and subsection 2 is that the former prohibits the discrimination of similar products and the latter prohibits the discrimination of competing products. Article 110, subsection 1 TFEU, which determines that no member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on the similar domestic products. For Article 110, subsection 1 TFEU to apply, one must first assess if a tax is imposed on similar products. Here the Court of Justice primarily looks at the comparability of the products from the perspective of a customer. Similar products. What are actually similar products? Products made from same raw materials same production methods, and having same characteristic are called similar products. An illustration is the case of Commission versus France Tobacco 2002, where France imposed a higher tax on the light cigarettes than the dark ones. The court held that they were similar products as they were made from the same raw material. Article 110(2) TFEU prohibits the internal taxation, which gives indirect protection to the domestic goods. It prohibits discrimination of competing products. The question arises, what is meant by competing products? If the customer regards the product as fulfilling the same customer need, then those products will be regarded as competing products. For a tax to be caught by Article 110, subsection 2, two conditions must be met. First, the relevant products must be in a competitive relationship. Second, if the products compete with each other, the tax may not protect the domestic product. Here, the Court of Justice primarily looks at the effect of the tax on the customers. In the case of Commission versus UK, for example, the Court of Justice found that the much higher taxes on wine did protect the domestic beer and hence was prohibited under Article 110, subsection 2. Because the tax difference was so high that it affected consumer choices, and the tax difference could not be objectively justified on any ground. For Article 110(2) to apply, therefore, a real protective effect must be shown. The mere existence of a difference in tax rate is not enough. Let's now talk about direct and indirect discrimination. In the case of Krozinski 2008, it was mentioned that if the charges levied on the imported goods are different from those imposed on the domestic products, then it will be discriminatory in nature. In the case of Hahar Petroleum, the ports in Denmark imposed 40% extra surcharge on the imported products than the basic charge paid for unloading of goods. It was only imposed on the imported products, so this was held to be a direct discrimination by the courts. If the same amount of tax is charged for both the imported as well as the domestic products, but the method differs in respect to the payment schedule, then in such a condition there will also be the direct discrimination. This condition was noticed in the case of Commission versus Ireland 1980, where the charges were to be paid immediately by the importers, but there was a compensation for the domestic producers to pay their charges within a few weeks' time period. In the case of Message Brzezinski 2007, the claimant brought a car to Poland where he had to pay custom tax for which he requested to be reimbursed. It was stated that if the tax was charged more than that amount received by the similar domestic product, then it will be the violation of Article 110 TFEU. Now moving towards indirect discrimination. In the case of Humlot 1987, the issue was related to the tax being imposed on the cars having engine greater than 1.5. This was held to be an indirect discrimination because the locally manufactured cars had a small engine. In comparison, the case of Commission versus Greece 1990, where Greece imposed a higher tax on the cars having more than 1800cc engine. Greece was not manufacturing such cars domestically. But this was considered to be objectively not the violation of Article 110. The justification was that it was for the protection of environment so that people will be discouraged to buy such big cars and pay such a higher tax only for a small change of engine capacity. In the case of Danske Bil Importer 2003, a very high registration tax was imposed on the new cars bought in Denmark. It was held that there was no breach of Article 110 because there was no Danish products to be protected. In the case of Commission versus Sweden 2008, the courts introduced another rule called de minimis rule, which emphasized that the difference in the tax values must not change the behavior of customers towards the purchase of domestic and imported products. In the case of Chemical Pharmaceuticide 1981, Italy taxed DSA with petrol at its base at a rate higher than the denatured alcohol obtained by fermentation. The reason behind it was to promote agriculture and reserve petrol for more important uses, so it was held to be justified based on the policy reasons. This was the first part of our chapter Free Movement of Goods. If you have any questions related to this chapter, you can ask in the comment section.